Hello, welcome to Legal Action. My name is David Siegel. Today we're going to be talking about orders of protection, especially related to divorce and family law cases. I want to welcome my co-host, Jesse Barrientos. Jesse, how are you today?
Pretty good, Dave. How about yourself?
Great. Thanks for being here once again.
Oh, you bet.
Jesse, orders of protection. This is something that goes on quite a bit, either with or without a divorce case. What's the general idea behind orders of protection?
Order of protection or order of protections are meant to be able to prevent domestic violence. If there's a situation, a lot of times people are in an abusive situation with either a family member or a boyfriend, or sometimes it's a situation where there's a disabled adult and they're being abused. So it covers a whole bunch of different kinds of things, and the whole objective is to provide the relief necessary so that the person doesn't have to go through that troubling time.
Now, some people get an order of protection after there's been an incident, and sometimes there's an order of protection preceding an incident to try and prevent one. What do you see more of, either after or before there's been an actual violent event?
Well, it doesn't necessarily have to be a violent event. There are all different kinds of things, and a lot of times there has to be some kind of a history. Something had to have happened. Whether or not somebody has called somebody, say maybe a husband has told a wife, "Hey, listen, I'm going to come and I'm going to grab the kids and I'm going to pull them out of your hands, and I'm going to, I'm going to go get my gun," or something like that. And if the other spouse or other individual, that would be the petitioner who's trying to get an order of protection, is really fearful that that's going to happen, and especially if there's a past history of physical violence or other incidents that are similar, then it makes it more likely they can get it.
Let's talk about the different types of orders of protection, because there are several.
Sure.
Let's say somebody comes to your office, they're not married, they're in a relationship, they live together in an apartment, and there's been some mental abuse, maybe a little bit of physical abuse, and all of a sudden there's a huge threat that I'm going to do X to you if you're not out of this apartment or something like that, and they come to your office. What are you going to do for that person?
Well, we're going to talk about whether or not they are really, really frightened, whether they're concerned for their safety. And I've had people tell me that, actually, I've had people come into my office who were physically abused, and the advice is immediately, actually before they come to the office, if that's what you think, you need to go immediately down to the courthouse and obtain order of protection, and they can get it on their own. It's called pro se. That means to represent themselves to take care of that, and that's what I usually do. In the context, and we'll talk a little bit about that later, of a divorce, we can do a temporary restraining order to be followed by a preliminary injunction, okay, which is very similar.
But in this case, this woman, in this example, there's been violence in the past. This gentleman that she lives with does have weapons. He's threatened to use the weapons. Now, he might just be, blowing smoke to try and scare her into some type of course of action or whatnot, but she's in fear. And she doesn't want to do it pro se. She wants to do it through an attorney. She wants to make sure it's done right. And frankly, she's nervous and she's upset.
Well, that's something that we would do and have to do immediately, and complete the order of protection. A lot of different places. It depends upon where you're at, which county, and the procedures are just a little bit different. But generally, the information that goes into the form and the forms are kind of the same. And so we would complete, first you would need a verified petition for an order of protection where you set forth some basic information. For example, your name, address, the name and address of the other person, some more personal information. But sometimes, if somebody has left a residence and they're worried that the other person is going to find them, might be a situation where their information, where they're currently staying, is not going to be recorded or put down in the petition for safety issues. So that's something that we would do. We would complete it. There would have to be some kind of allegation. Why are you here? What did the person say? And that would be included in the petition. There would be also allegations probably of the previous situations that led the person to believe that the spouse or the boyfriend or fiance was going to act on those threats, especially if there are guns or other type of weapons involved.
So with regard to these allegations that the petitioner is going to allege in this petition, they have to be imminent, right? They have to be realistic. They can't be, he might do this in the future. It's got to be pending immediately. Is that correct?
Yes, you have to be worried that that's going to happen. This brings up also another concern too, that if, depending upon the level of the threat and the the severity and the circumstances, because each situation is really different, that might be also an issue for the police. We have here assault and battery. Battery is unpermitted, unlawful or offensive touching of somebody, and it can be as, and I don't want you to prosecute me here, Dave, but it could be as
Right.
little as that, as yanking
It could be
something out of
spitting
your
on
hand.
someone as a
It
battery.
could be spitting on somebody.
Right.
It could be me just laying my hand on your shoulder, or it could be me clocking you. And we have all different kinds of things that happen. So, because order protections also happen in the course of a battery. So if it's something like that, say that it's not a touch, it's an assault. Assault is a threat that the person has an imminent fear of danger immediately. Although I don't think the police really arrest folks for that so much, but it is an arrestable offense. And what that can do is get somebody out of the house to give the other person an opportunity to give them to cool off, and also give the other person an opportunity to go out and to get that order of protection.
Okay. When would this mix with a divorce case?
Well,
Or is this something they do separately?
Well, there's a whole bunch of interplay with that, but before we kind of go into that, we need to explain just a little bit about going in for your order of protection. You fill out the forms and you file it as an emergency. An emergency order of protection basically is saying, hey, listen, I'm asking the court to grant this on an emergency basis, ex parte. That means just one-sided, without the other side participating. And the reason for that, I'm saying, is because, okay, here, Judge, if I let the other person have notice, he's going to do the exact same thing that I'm afraid that he's going to do, that I've alleged in the order of protection. And depending upon the evidence, the judge, it's a verified petition, and the judge is going to ask me some questions about that and look, and if the allegations are sufficient to sustain the entry of an order of protection, the court is going to enter an emergency order of protection. That brings up another concern.
Yeah, who has notice?
Well, and it's for an emergency, is for 21 days. But in order for it to be effective against the other person has to be served with it. And generally they'll give it to the sheriff to go and serve that person. But until that person is served, they can't violate it because they haven't been personally served. The court doesn't have what they call personal jurisdiction over that individual.
And that service by the sheriff in these cases is done without cost to the petitioner. So
That's
free.
exactly right.
Okay, that's a service that the county provides.
Right. There's
the
no
sheriff's office
for
provides.
order protection. There's no worries about that. And then you've got your hearing date. Then would be set in 21 days, and hopefully the other person gets served. Then once they're served, you come in on that date and you have your hearing on the order of protection to see whether or not it's going to be extended, or whether or not after the hearing the court decides and the judge decides that, hey, listen, we only heard your side of the story, but now we're hearing something different. And that's not a basis, and it might be a precursor to get an advantage in a divorce. And that's where we're talking about that. A lot of times people use it.
Right. What are the typical scenarios, though, at that hearing on the 21-day date that they return? What is the typical outcome in your experience? Are they continued? Are they dropped? Is there just a stay-away order mutually? What happens?
Well, first, on the initial order of protection, I think a lot of times the judges want to err on the side of safety. But it's also sometimes, they have to weigh the hardships, because some of the remedies that you have in an order of protection are exclusive possession of the residence. So if the judge enters it, hey, you're going to be excluded from the house. Now you don't have anything once you're served. Okay, you can't go back in or violate it, otherwise you're going to have some other problems. Now, if they serve you at work or some other place, you can't go back home. Now what do you have? You've got the clothes that are on your back. But a lot of judges still will err on the side of the safety of the individual. A lot of times it also involves children too as protected parties that they want to protect. And but you can come in on 2 days' notice to try to vacate that.
And I've seen that quite a bit, especially in cases where respondents feel that the emergency order was entered in error or without merit. They don't wait the 21 days. They immediately come running in to vacate that emergency order.
Right, and they have to file the motion to vacate. But in those initial contexts, I think I see, a lot of times the judges are more inclined to grant them for that reason. But it's important for people to know, and I've done that too. For me, what I want to know, and what I always try to do, is get the transcripts, because they're always recorded it. I want the transcripts from that initial order of protection to hear what the petitioner has said to the court, so that, I can properly and adequately represent my client.
Isn't it mostly going to mirror what the allegations are in the petition itself?
That's the assumption. It may and it should, but as me doing my due diligence, I really need to get that. Now, in a perfect world, you'd have that, but a lot of times if you're running in on those 2-day notice, you don't have the benefit of that. But I think if they're at all possible, you can do that. That's the way to be able to do it.
Yeah, and that stems from your background as a criminal attorney as well, because I know in the past with DUIs and things like that, you wanted those transcripts. You wanted to know exactly what was in the police report. You wanted to know what was said at the initial hearing because you wanted to be able to attack it, correct?
Right. I want to know exactly, and then once it is, you have it in the transcript. I mean, that is a statement made to a court, to a tribunal, and it's made under oath. So a lot of times, I had one recently where the allegations in the petition for the order of protection was a little bit different than what they had testified to, and it wasn't in there. And so again, that's something that you need to know to be able to kind of lock them down. But you were talking before about what happens at the hearing.
Yes. What happens at the hearing?
So it really depends on the situation. A lot of times, again, it depends on what it is. Sometimes there are situations. I had one just recently where my client had custody in a different state, and actually had filed a petition for dissolution of marriage and had an order of temporary custody, and the wife came to Illinois with the child and got an order of protection. She didn't tell the court that there was another case pending in the other state, didn't tell the court that he had a temporary order of custody. Mm-hmm. And it took a lot of work, and we filed the appropriate motion to vacate and everything else, and eventually, after a hearing, we had to go a couple times, it was granted.
Yeah. What was the name of that case?
Just kidding. I can't tell you, Dave.
I'm testing your ethics, which are...
I can tell you it's a matter of public record.
Yes.
But I can't tell you that.
Yeah, no.
Anyway, so that's what happens, and it just depends upon the specific circumstances. A lot of time, the court, and I've seen courts and judges, well, just like anything else. I've seen judges enter orders of protection that I don't think they should have, based upon the law, because the other side didn't meet the specific elements that are required for the order of protection. Now, this is a situation, should the judge have entered it pursuant to the law? No. Should the judge have actually entered it? Yes.
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 Let me ask you a question, too. A lot of times judges in other areas of the law tell people to go out and talk in the hallway. Use the hallway. That's going to resolve the case. I would assume that in orders of protection, that's not something that the court can do. So they're going to have to hear the testimony. Is that correct?
They're going to have to hear testimony. They also have what they call the advocates, which are people who talk to and are trained, and they talk to the petitioners, the people who are seeking the order of protection. And generally what happens, a lot of times you have, again, it's pro se. You don't have lawyers involved. A lot of times it's just that individual petitioner that's pro se, and the defendant or respondent gets an attorney. Sometimes you have the situation where both parties have attorneys, and I like that better because there's more depth of understanding and interaction, because an attorney knows what the law is, and they know the realities, where a person who's doing it on their own really doesn't have that understanding. But if you have a situation where there's a couple of pro se people doing it on their own, the advocates will talk to the petitioner, even in a case where I've represented respondents, and they will, I'll tell them, hey, what are we doing here? The person, either doesn't want to pursue it, and a lot of times they don't.
Is this a criminal offense? If an order of protection is extended for up to 2 years, is this something that is going to be on record, and authorities will be able to look upon this when they either arrest you or pull you over for driving? Is it something that's going to be on record?
It's on record, but it's not a criminal offense. So let's say we get to the second hearing and the judge enters it or grants it, extends it. Then it becomes what they call a plenary order of protection. Emergency order of protection up to 21 days. Sometimes they can extend it if the other person hasn't been served. They can, if the judge determines that it should be extended, extend it for any time beyond that, and that would be a plenary. Could be 30 days, could be a year, 6 months, could be 2 years, which would be the max they could extend it, and it's set on that date to come back to see whether or not it should be extended again. But it will be on record. They will know that. Sometimes, a lot of the remedies are you can't possess a firearm. So if maybe you're a police officer and you have a order of protection against you, or you're a soldier in the armed forces, that's going to be a real problem. If you are a security guard, that's going to be a real problem. certain jobs, if you have an order of protection against you, that's going to be a real problem.
Right. Well, the judge might make an exception for while you're on your job.
That's correct.
But 2 years is the maximum extension. Is that correct?
That's right.
That seems like an awful long time to extend an order of protection. You're talking about, what, 700 days?
Well, let me
730 days?
It may be. Let me explain. There was another case that I can't tell you that was involved in, and this was before I came on board, but initially what had happened, the husband went to prison for trying to kill the wife and the child. He used a motor vehicle, and the child was there too, and so, he went to prison for that. And so that is certainly an appropriate remedy. Now, people have to understand, the folks at home have to understand that an order of protection is just a piece of paper. Mm-hmm. It's not going to prevent somebody from doing you harm. What it is going to do is it's going to make the penalty more severe.
Should it be violated in the future?
Exactly right. So a lot of times as we're talking about the orders of protection, they will be just based upon an incident, based upon somebody being in fear, or sometimes it will be based upon an actual battery, a domestic battery, having been committed. And so now there's a criminal charge against the respondent plus the order of protection. Sometimes it will be, a lot of people use it as a precursor for a divorce because they want to gain an advantage and they want to get custody, or they want to get the other person out, or do all kinds of things. So they'll go in and not be completely accurate or candid and get an order of protection and try to dictate the tone of the inevitable dissolution of marriage action.
Yeah, I wanted to talk to you about that tactic of somebody going in and filing kind of a quasi-meritless order of protection action just so that they get the order that separates the spouse and the children.
That's right.
From that spouse. And it kind of sets the stage for, I don't want to say sole custody, but you almost de facto have it if the 21-day order kicks in and then it gets extended.
That's right. That's why it's important if you're going to, and again, remember what I was talking about before about getting the transcript. That's why that, kind of becomes important. However, in a lot of the counties, depending upon where you're at, if somebody has filed an order of protection, because you get a different judge. There's a judge that's assigned to do orders of protection. And then there are the divorce judges who handle the divorce cases. So in a particular county, the rules are different, but generally what will happen is if an order of protection is filed and then subsequent to the order of protection, before the hearing on the order of protection, if a dissolution of marriage action is filed, then what will happen a lot of times is that order of protection judge will transfer it to the judge that is going to hear that case.
Okay, so it'll all be combined, consolidated at some point.
As it should be, because if this is a judge who's going to make a determination on everything and the issues are similar, that's where it should be for judicial economy.
Okay. What's your best defense, other than getting the transcripts and attacking what allegations were said? What sort of defense would you have if someone actually did make an overt threat and it was possible that that threat could be carried out? What sort of defense? How do you represent somebody in that case? What do you do for them?
I'll tell you. So you're saying if there was a basis for the order of protection. Again, each case is a little bit different, but a lot of times what we do, and again, when we're crossing over now into the sphere of domestic relations, of the divorce law, and you're in front of that judge, what happens because of the order of protection being on your record and maybe causing problems for work? Because let's face it, if there's a divorce, we're going to need support here because that's appropriate. And if it's going to interfere with somebody's ability to maintain a living and not to be able to pay child support to a spouse, nobody wants that. And although sometimes people want to punish the other person, we see a lot of that too. And sometimes they want to punish the attorney too, Dave, if I know that's a surprise for you. But what will happen is we will enter a mutual restraining order. We'll get rid of the order of protection, enter a mutual restraining order that pretty much says most of the things that are in the order of protection, that the person, the respondent, is prohibited from harassing, from alienating, or from doing any of those kind of things, from restricting their freedom. And so it's in the court order in the divorce action, and the order of protection gets dismissed.
This mutual restraining order, do they call it different things in different counties?
I think they do.
Okay, because I think in Lake County they call it a stay-away order.
Right.
But what do they call it in DuPage and Will?
Well, I mean, I've always thought of it as a mutual restraining order, because that's what it is. It's a restraining order. It's restraining you from doing something.
And it's by agreement.
And it's by agreement. I mean, that's if you can come to an agreement on it. And I will tell you that goes a long way into, again, dictating the tempo of the upcoming divorce. And let's face it, divorce is a bad thing, but they're inevitable, and that's what happens. And the best thing that you can do is to try to resolve it and to try to keep that with a mind with the children. Because regardless of what people think, the children know what's going on. They're not stupid.
Okay. Let's talk about some of the consequences when an order is violated. So somewhat down the road here, within this window of time, there's another either threat or action that violates what the order says, what the order prohibits.
Okay.
What happens in that case?
So if we're talking about an order of protection and we haven't done a mutual restraining order, we do the order of protection and it gets violated, then that's an arrestable offense. Let's say that there's an order of protection against you and you go to, you're not supposed to be at the house. You go to the house, knock on the door, that's a violation. Even contacting somebody on the telephone, depending. Now, sometimes they modify the provisions and the restrictions in order of protection to allow for visitation. So sometimes a judge will enter an order of protection, but will not find that the child is a protected party and will modify it, excuse me, just so that visitation can be effected.
Well, this arrestable offense, who enforces that? Does the petitioner go back into court in front of the same judge, or does she just pick up the phone, call 911 and say, look, I got an order of protection, he's at my door, I want him picked up?
You pick up the phone and you call 911.
Okay. Let's talk about another situation which someone has an order of protection issued against them. Say it's a 2-year plenary order. And all of a sudden, in that window of time period, the couple is kind of not reconciling, but they're communicating, and the communication is being instigated from the petitioner who has the order of protection. What should the respondent do in that case? Because obviously they're communicating, it's being instigated by the petitioner, they're kind of reconciling to a certain extent, but yet there's this order of protection that they're one snap fight away from the petitioner picking up the phone and saying he's violating the order of protection.
You know what I'm going to say, Dave, because you know me. It's a violation of the order of protection. Don't do it, don't do it, don't do it. Sometimes the petitioner is trying to lull that other person into a false sense of security in order to put the whammy on him.
But we're human here.
Of course we're human.
She's calling him.
Right.
They're getting together.
She's tugging at the heartstrings.
They're going out to eat.
Right.
They're playing with the kids, whatever it might be. There's still this underlying order of protection that says no contact.
It's a violation, and if she called the police, he's going to jail. Now, it doesn't matter because the order of protection prohibits this, and he has violated it. The judge may take some consideration, but generally, I think it is what it is. What should happen, therefore?
What should he do?
What he should do is he should go to his lawyer, and he should have his lawyer file a motion to modify. And
he's indigent.
Well, then he could go to the court and to try to do a pro se motion. If the parties are in agreement, and they could advise the court that, hey, we're trying to reconcile. And so, I don't want him over here overnight, but we want to try to reconcile. So, and the order protect. See, judges don't. I mean, they're doing their job with respect to the divorces. But if a family can reconcile, that's a beautiful thing. And so I believe, again, each situation is different, that the judges are going to allow that to happen if it's at all possible and if it's in the best interest based upon the circumstances of the specific situation.
I think parties are reluctant to go back into court, whether it be for money reasons or otherwise, and they live the way they're living with that underlying order hanging in the balance, and they just hope against hope that it doesn't erupt to a situation where it could be criminal.
Well, the other side, the other party certainly likes to have that ace, because now who is the power? Who has the position of power in that scenario?
Sure, the person who has the order.
Protection. Right.
Okay.
Exactly right. We talked about before about doing. If you were already in the context of a divorce, you could certainly go in on an order of protection and bring a petition, and depending upon where you're at, it would be heard in front of the same judge who is hearing the divorce. But you can also do other things as well. You could file a petition for a temporary restraining order to be followed by an injunction. They're similar. Temporary restraining order, same deal. It's only entered for a short period of time, up to 21 days, until a hearing can be had. And then once a hearing is undertaken, and if the court agrees, now it turns into a instead of a temporary restraining order, a preliminary injunction that can go for a much longer period of time. And again, you're seeking to restrict somebody from doing something, or sometimes you're seeking somebody to do something. Sometimes we file petition for temporary restraining order. Well, I mean, for different kinds of things, if somebody takes money out of an account or something, but sometimes we do that because, there's a threat.
Yeah, and that's done without notice initially.
That can be done without notice too. But what I always like to do, if at all possible, is to, especially if there's an attorney on the other side too, is to give some kind of notice. Give them a call or fax them something, or hey, give them kind of a heads up that this is going on. Because we just want the court to make a determination to be able to resolve the situation.
Right. I guess not as strong as an order of protection, but if the two parties are living together in the same house and it becomes unlivable, one party can bring a motion for exclusive possession of the marital home and actually have somebody put out of the house, where it's not an OP, but it is to the same effect. You've removed that individual from the marital residence.
Right, and that's a little different than when you go in, again, ex parte for the emergency, when the other party isn't there to defend himself and say, hey, yeah, I did that, or no, I didn't do that, or I don't know what she's talking about. She's the one that pushed me down the stairs.
Right, and of course, if the judge doesn't hear those allegations that they need to hear in the emergency or temporary motion, it's going to get denied. It's going to get thrown out.
Yeah.
If the judge doesn't hear enough to
sustain the burden.
To sustain it, yeah.
Sure. If I go in to get an order of protection because, you know what? She yelled at me. She hurt my feelings.
Yeah.
Well, that may be, but it's not.
There better be a threat.
Right. And you have to prove things, for example, like that you're a protected party. So if we've ever had a relationship with somebody, if it's just somebody that, someone from work, that's not a protected party. Then you have to pursue another avenue to be able to do that. So, order of protection isn't, you can't just pick somebody, oh, look here, there's this person named Rachel who looked at me strangely. I'm going to get an order of protection against that person.
Yeah. We just have a few minutes left, but I do want to point out a couple things which I'm sure you'd agree with. The statement order of protection is really a misnomer because, like you said, it's a court order. It's not really protecting you. It's an order that if it's violated, somebody could be taken away and locked up. But really, your best form of protection is to do what if you feel threatened?
Is to call the police, get out of that situation. Again, the whole thing is for domestic violence. That's such a terrible blight on American society and actually other places as well. And so, you have to do what you need to do in order to take care of yourself. And if that means going to a shelter, and there are shelters, that means calling the police. If there's an immediate threat, call the police, call 911. Get out of that situation and then deal with it afterwards. But you have to be protected. And there are shelters out there for folks who are in that situation.
Yes, or family members or friends.
That's right.
Just remove yourself from that violent situation, dangerous situation. But obviously, if you need to avail yourself of the order protection statutes, you want to go ahead and do that as well.
You want to do, and you want to act immediately.
Okay. Well, Jesse, thank you very much for being with us and all the knowledge that you have in this area. In terms of order protections, either with or without a divorce case, that's what we talked about. We'll see you next time on Legal Action. Thanks for joining us.
Yeah, it's really important for folks.